Welcome to your ultimate guide to the world of intellectual property law. Whether you are an inventor, entrepreneur, or simply curious about how ideas become protected assets, this podcast is for you. Each episode, Spoor and Fisher partner and legal professor, Professor John McKnight, will explore the intricacies of IP and delve into specific disciplines to guide you through patents, trademarks, copyright, and more. In this week's edition, Professor McKnight discusses IP insights, the rights and the wrongs.
Hi and welcome to the Spoor and Fisher presentation on intellectual property basics and management. We should begin by introducing intellectual property and addressing the question of what is intellectual property. So if you've ever done a course on IP, either at university or during the course of an MBA or some other studies, you'll probably have come across the definition that intellectual property law protects the products of the intellect which are capable of commercial exploitation. Now, unfortunately, that's not a particularly helpful definition, so we'll drill down into that and hopefully make it more practical during the course of this presentation. But really, the takeaway is that IP law is the conduit through which innovation becomes intellectual property. So what is intellectual property? It's property in the sense that a house or a car is property. The only difference is that intellectual property begins its life between somebody's ears. A house or a car is tangible property, but intellectual property can be considered to be intangible property. And there is a lot of commonality between intellectual property and tangible property. Like you can buy and sell intellectual property, just like you can buy and sell tangible property. You can buy and sell houses and cars. You can allow somebody to use your tangible property. You can rent your house out, you can hire a car, and it's exactly the same with intellectual property. You can license intellectual property, which means you have the right to use it even though you don't own it, and money usually changes hands in that situation. But the commonalities go even further than that. To use your house, to use your car, you have to pay rates and taxes on your house, you have to pay license fees on your car, and it's the same with intellectual property. Patents, trademarks, designs, they have annual renewal fees payable with them. So that allows you, by making these continuous payments, it allows you to use the intellectual property, and more importantly, it allows you to stop others from unauthorized use of your intellectual property, just so that you can stop squatters on your land or in your house, and you can stop unauthorized use of your vehicle, which is straight up theft. So you can see there's a lot in common between tangible property, houses and cars, and intangible intellectual property, and we're going to explore those differences in greater detail now. There are basically the big five in intellectual property. Just like we have the big five in game reserves here in South Africa, we have the big five in intellectual property, and they are patents, trademarks, registered designs, copyright, and know-how. Now, the first three, patents, trademarks, and registered designs, they have to be registered. We've got a patents office in South Africa, like most countries around the world. We've got a trademarks office. We've got a registered designs office. You don't have a patent right unless you've gone down to that office, registered your patent, and paid the monies which are due in order to get that registration. The same is true for trademarks. The same is true for registered designs. Copyright, however, just comes into being upon the creation of the work. So that's an important distinction. And then the fifth of the big five is know-how. And that's secret and confidential information, which again exists upon its creation, but doesn't have to be registered anyway. So apart from these big five, there are other species of intellectual property, for want of a better word, such as plant breeders' rights, or database rights, or topographic rights in computer chips, and things like that. But we won't really concern ourselves with those today. Today, we'll just be concentrating on the big five. So let's talk about patents first. So patents protect ideas in an industrially realizable form. So a patent can protect a new product, a new process, or the new use of a product. And the thing about a patent is it's really a solution to a problem. It's a solution to a problem that's not obvious to anybody, and it solves the problems that afflict society. So patents are drawn to new kinds of drugs, pharmaceuticals. They're drawn to more efficient way to catch mice. They're drawn to new mining techniques. Anything which improves upon the situation as we know it, which is called the prior art. If a patent improves upon that, if an invention improves upon that, then it's eligible for patent protection. Trademarks, on the other hand, are badges of origin. They serve to identify your products and distinguish them from those of your competitors. So, for example, Coke and Pepsi are both carbonated, cocoa-flavored beverages, right? But if you walked into your local shop and said, "Can I have a cocoa-flavored carbonated beverage, please?" they'd look at you like you were crazy, and they'd be right. We reach in the fridge for the one that we like, and we reach for the one that we had yesterday or the day before, and we know that we liked it, and we want exactly the same again. So it's a badge of origin. It turns on reputation, and that's why trademarks are so important, because they drive point of purchase decisions. I want a Coke because I like Coke. I prefer Coke to Pepsi, and so I reach for the Coke in the fridge. And therein is the intrinsic value in trademarks. Copyright protects artistic or literary works, and no merit is required. And that's an important distinction. Can you imagine if merit was required before you had copyright protection? You'd have some crusty old judge denying the Rolling Stones copyright protection because he's more of a Beatles man. See, we can't have that. So it's got to be objective. So as long as it's an original work, then it's subject to copyright protection. And we're going to explore this in greater detail down the line. But basically, copyright covers literary works, musical works, artistic works, radio broadcasts, all good things like that. And you can see how ubiquitous copyright actually is. It also serves to protect software. So you can imagine copyright is massively important in industry. This is an interesting one. Registered designs just protect the outward appearance of industrially produced articles. So it's got nothing to do with how it works, which is covered by patents, but it's got everything to do with how it looks. Okay, so now why would this be important? Why would this drive preferences in the marketplace? Well, let's just take the example of kettles, right? So you can get a pineware or an entry-level kettle for about $400 in Pick and Pay. It heats your water. It'll make you a wonderful cup of tea or coffee. It's really great. So why on earth would you pay 5 or 6 times that for a cool-looking Smeg kettle that does exactly the same thing? And the answer lies in the outward appearance of the kettle, in the aesthetics. A Smeg kettle looks a lot cooler than a pineware kettle. And if you want it in your kitchen where you're entertaining guests, or even just for your own enjoyment, a Smeg kettle is easier on the eye. And that's why it pays to have a registered design for the outward appearance of an industrially produced article like a kettle. The Smeg and the pineware do exactly the same thing. The water that comes out there is at the same temperature, but people will pay a lot more for a cool-looking kettle, and that's because of registered designs. Then finally, know-how is an unregistered body of confidential and or proprietary knowledge developed over time. And it's obviously only of value while it's kept confidential. So how does this work in practice? This can be anything from a salesman little black book. So he knows, oh, John, I sell him 24 reams of paper, in January every year. It's time to call him up. And I'll make a note that he's got 3 kids. One was writing matric last year. Hey, John, how's it going? How did the matric go? Are they going to university? That's fantastic. We still up for your same order this year? You don't want to increase it or anything? So it's that kind of thing. It's like a body of knowledge that is held between somebody's ears. It doesn't have to be written down. But it can also, translate to the factory about how, the factory settings are tweaked to take into consideration whether it's raining or not, or just how to maximize yield in production processes and things like that. And it's knowledge held by the operators. It might be written down, it might just be held in their heads. But either way, in either of those scenarios, you can see how much value can reside in know-how.
You are a leader, a visionary. You embrace technology to develop cutting-edge solutions. You are original and innovative. You imagine. Trailblazing is often a lonely path, but we see the extraordinary in what you do. When it comes to understanding and protecting your intellectual property, your journey is our journey. Visit our website at spoor.com and discover how we can protect what is uniquely yours. Spoor & Fisher. Create it. Own it.